Now, I'm going to get to the law, and I know I'm talking too much, but the last thing I wanted to mention on Senate Bill 777, which is kind of fun, is it does have this provision in there that says at the end of the bill that all payments that come from a casino shall go to the Fireman's Annuity and Benefit Fund for payment of the pensions. So, you're not going to get more than is owed, but if there's a casino, it says all payments from the casino will go to the Fireman's Pension and Annuity Benefit Fund for pensions. Now, it says that, but it also says that in the police pension section. All payments for the casino shall go to the police pension fund. Now, as I said yesterday, we're a lot smarter than those policemen, so we're going to get the money first. But I will say that it does seem kind of hopeful that now the legislation got passed by Governor Pritzker that there may be a casino. And if there's a casino and there's money that generated from that casino, and it's, you guys probably know, there's likely to be money generated by that casino, depending on where it goes, that money is going to be available to pay us. So that's a good revenue source. I'm not sure it's going to generate $200 million or $300 million a year extra, but it is out there. The union was able to get that in the bill, and I do think that it's something you guys should watch. You may be against casinos. Oh, it's not good. It'll take money out of your pocket, but it also is going to put money in our pocket. So I'm a big advocate. I'm working hard to encourage people that we get a casino, that the casino goes downtown. You're adults. You don't have to go there if you don't want to go there. But if tourists come in and go there, hey, let's get that money and put it in our pensions, right? So it's an option we have. It's a new tool we have in our toolbox, and hopefully it's one that you should watch and you should encourage. If you guys want to write your aldermen or your legislators, you should do it. Say, hey, let's get this casino, let's get it in Chicago, let's put it someplace that's going to make money. Think about it. Does the casino do very well down at the Geary Works or by South, the U.S. Steel site on the south side? I don't think so. That's just going to take our money and move money around. We ought to put that casino someplace downtown. You have tourists come in and use it. You have people out to dinner spending a couple hours blowing their money. That's what we need. We need people to encourage that. I'm sorry? Well, that's going to be the law, and that's why you have bulldogs like Sarah, my partner who's not hearing me, in your pension fund. Your pension fund has a fiduciary duty to collect every dollar due and owing to the fund. And I assure you that those trustees will be all over it. They will get every single dollar. And I remind you, we have a mandamus action that we talked about earlier, where we can go into court and say to a judge, Judge, this says in the bill, all payments go to the pension fund. It's not some, it's not, net, it says all payments. So if the city gets money, we have the right to get that. So yes, I'm not worried about that at all. Now the bill can change, but to the extent money comes from the pensions, we're going to get it. Now, I'm not sure we're going to ever get a casino, but I hope we do. I think it'll be a good thing. Okay. Does that answer your question, sir?
Yes, ma'am.
Okay, terrific. All right, so now we got to talk about the law, though, because I've told you that the funding is changed. We went from a less secure funding stream to a more secure funding stream, which is ARC. But now we have the ramp, right? So we've had some changes in the funding. And there's no doubt we're not well funded. We all get that. And so, but you can't look at funding without putting it in the context of the case law. So, the first case, the big case that started all this, was a case called Sklodowski versus the state. And this was a case brought by people who said, hey, wait a minute. I know you're giving us benefits. We know we're going to get the benefits. But we aren't comfortable getting the benefits. We want the money actually in the bank. We don't trust you. We want to know that me, or I'll take Trustee O'Sullivan. Trustee O'Sullivan's entitled to an annuity, say, of, he'd like this, $100,000 a year. and he's going to live another 30 years. He wants to know that that money is in the bank for him, ready for his retirement. That's not going to happen, but that's what these people sued for. They said, hey, wait a minute. We don't want this uncertainty. We don't want this angst in our bellies that the money's not going to be there. And ultimately, the Supreme Court said, hey, the Pension Protection Clause tells you you will get your money. What Sklodowsky said, what the Illinois Supreme Court said in Sklodowsky, is that having the Pension Protection Clause in the Constitution, look at their words, serve to eliminate any uncertainty as to whether state and local governments were obligated. That's a strong word. It took away any uncertainty as to whether they were obligated to pay pension benefit to employees. And the court said, and it demands that the benefits of those relationships not be diminished or impaired. But it did have kind of a downside for funding. What it said, and it's why you can't be worried though, it said, hey, you get your benefits cannot be diminished or impaired, but what you don't get is you don't get the comfort of knowing that all the money's in the bank. You don't get to know that there's 100% in the bank, so you sleep at night. They said that annuitants are not entitled to a particular funding mechanism, and that the only time you could really complain about funding is if the entity that's responsible for the pensions was on the verge of default or imminent bankruptcy. Okay, so that was a big case. It said, hey, you can't mess with people's pensions, but you can't force the city to pay us. They can be what's called a pay-as-you-go system, and that would be, for instance, say we needed $100 million to pay pension benefits in any year. Technically, we could write the city and say, hey, we need $100 million, send us a check for $100 million, and they'd have to do it. That's not the best way to run a railroad, though, right? We kind of want to know we have money in the bank. But Sklodowsky said, don't worry your pretty little heads about it. As long as you know you're going to get your benefits, and they are going to pay you, you don't really get to sort of force them to put the money up front. The money doesn't have to be there. Okay, so that's the law in 1998. The next big case is the case that you were referring to, sometimes called Heaton and sometimes called in-rate pension reform. And that came in 2015. And that's the case, as the gentleman said, I'm sorry, what's your name? John. That's what John said. He's absolutely spot on. What they did first is they tried to mess with the state employees' benefits. They went in and they said, hey, you're not going to get your COLAs, and you're not going to get them every year, and you're not going to get them compounded. You know, they went in and tried to mess with the benefits, and the state employees right away turned around and they sued. And in this case, in-rate pension reform litigation, again, went up to the Supreme Court, and they did the exact same thing. Now we're, 17 years later after Sklodowsky? Different people were sitting on the court, but the court did the exact same thing. It said, hey, don't worry your pretty little heads about funding, because you are going to get your benefits. They're not going to be affected. And the only time you can really bring a lawsuit for funding is if the state is on the verge of default or imminent bankruptcy. So, and it has to be a really high standard. They said it's not just your opinion, like, oh my God, I'm like nervous. I don't think the city's going to pay. We have a new mayor. It really has to be economically driven, that they cannot pay their bills when they're due. And they also said, and I think this is really the most important part, and I was involved in this case because I represent some state pension funds, and I was actually at odds with the Attorney General at the time, because the Attorney General was trying to uphold the pension reform bill, and here I am, a state pension fund, arguing that she was wrong, that she didn't like very much, but it was because she raised this argument. In the state case, what the state argued was that, yes, we understand there's a pension protection clause, And we understand that pension benefits should never be diminished or impaired. But we also think, very paternalistically, they said, that there's this thing called the police power. And whenever the state feels that somehow it would be in the best interest of the public's health, safety, and welfare to reduce pensions, we should be able to do it. That we have the power. We are, in fact, like the parent in this relationship. And if we decide it's not, that the money is better spent on something else to protect the people, we can go in and take away pensions. To me, that was the single most dangerous argument, because they'll always come up with a reason why funding schools or funding hospitals is better than funding your pensions, right? That police power argument was a killer. And this case from the Illinois Supreme Court went my way and not the state's way. What the Supreme Court said was, you cannot do that. You cannot use the police power to reduce benefits. So that should make everybody in the room exhale. Because that's a good one. Because what we talked about with the city, and her looking at $327 million that's due in a couple of years to just our pension fund, you could see her going in and saying, if I give the pension funds $327 million, or the fireman's fund $327 million, I'm not going to be able to keep police on the street. I'm not going to be able to keep the water system running. Those are health, safety, and welfare issues that should trump the pensions. And this case clearly said, no, it cannot be used. You got to figure out another way. And in fact, anecdotally, I'll tell you, that's what happened with the state. I know I'm over my time. What the state did was, you remember a couple of years ago, before this this case in 2015, all the newspaper articles, all the things in the paper on TV were all that the state had this huge pension problem. Do you remember that? They were talking about the huge state pension problem of the state. You know, politicians were like, there's a huge pension problem. And now you hardly ever hear about the state's pension problem, right? It's because they funded the pensions. Now they have a health and services problem, don't they? Instead of funding schools and hospitals and social service agencies, they decided after that case, well, we better fund the pensions. And the money went to the pensions. Because money's fungible, folks. So this was a good case for us. Because this case says to the mayor, don't tell us there's a pension problem. You've got to pay the pensions. Now that might cause a problem for you with education or hospitals or street pavings, but that ain't our problem. So this is a good case for us. Okay, so that's 2015. And then they came at your COLAs and things. In 2000, with that, some of the laws that they passed, they tried to change the COLAs for the municipal and labor workers of the city, the MEABF, which is the Municipal Employees Annuity and Benefit Fund, and the LABF, which is the Laborers Annuity and Benefit Fund. But anyhow, in 2016, knowing that laborers and muni were in financial straits, they tried to reduce the COLAs for them. They wanted to reduce the value of the automatic annual increase. They wanted to go from 3 to 1.5%. They wanted to eliminate it in some years. They were going to do odd years. You'd get your COLA in 2013, then you wouldn't get it again in 15, et cetera, then 17. They wanted to postpone when you got your COLAs. They wanted you to wait till you were 67 or 68, and they weren't going to be compounded. And again, our Illinois Supreme Court, your Illinois Supreme Court was really strong and consistent, and we were in this case too. And they said, no can do. You can't tell us that COLAs are not benefits because they haven't been actually realized. They said, if you take away the COLA, you unquestionably diminish the value of people's retirement annuities. And they said, those were promised when they entered into the system. So think about that. What they're saying there is, the day you went into the system, each and every one of you, that changes. But whatever benefits were on the books on the day you entered the system, those are the benefits you get when you retire and for as long as you're alive. They cannot change those. So that's really gives you a lot of security, I think. So they struck that down, and they also reiterated what they had said in the in-rate pension reform case, and they said that you get the benefits, but getting the funding isn't a benefit. So the funding's not the benefit. What's protected is your COLAs, your retirement amount, your any of those terms. Those are what's protected, not the funding. Again, they reiterated, and I know it's repetitive, but I love it. They said you have a legally enforceable right to receive the benefits you've been promised, not merely to receive whatever happens to remain in the funds. So that's key to me, because like John said, we're 21% funded this year, and so that means we only have, in effect, $21 for every $100 we owe. Now that's not right, but that's kind of a simple way to understand it. That ain't good, right? But it really doesn't matter. What the Supreme Court said is, that's just the money in the fund. Don't worry your pretty little heads. What you have to pay, Mr. City, is 100% of what's owed. Don't look at what's in the fund. The city's got the money. They've got the power to tax. Raise, do whatever you have to do, you got to pay. We're not limited to the money in the fund. And that is what the city had tried to argue, by the way. The city tried to argue that, hey, the money's in the pension fund. If the pension fund can't pay the bills, then the pension fund will just have to go bankrupt. And this case said, no, that's not what's going to happen. Okay, so I'm feeling really good, right? We've got Sklodowski in 98 that says you get your pensions. We've got the Supreme Court in 2015. You've got the Supreme Court saying it again in 2016, directly applicable to city pensions. So then along comes Harvey. Now the city of Harvey is not the city of Chicago, right? The city of Harvey's got some very severe economic issues. But it's an interesting case, and we wanted you to know about it, because in 2010, in the Harvey case, there, the city of Harvey didn't make any payments to the pension fund. So it's indicative to us, it's helpful to us, because now we know we can do what Harvey did. Harvey went in and said, hey, do you remember back in 1998, in the Sklodowski case, or the pensions in the city of Harvey went in and said, you told us we could go in and get forced funding. We can force them to pay us if we're on the verge of default or imminent bankruptcy. And Harvey's the first case that told us what did that mean. In Harvey, the pension fund was not declaring bankruptcy, but they also weren't making any of the payments. So the pension fund was very successful in getting them to realize that, getting the court to force the city, in that case, to pay. So here's a chart that shows what the city of Harvey was required to pay every year and what they were actually paying. And you can see that, like, for instance, in 2013, they made no payments to the pension fund. In 2011, they made no payments to the pension fund. Yet they were levying the taxes. So they were taxing for the pension funds, but they weren't making any payments. So there's something goofy going on there in Harvey. But the important thing from our perspective is that that's not what we have here, but it does show that if, for some reason, the city were to stop paying the pensions, or the city was to just say, no, we're not going to do it, we have the tool, the Harvey case, to go in and force them to do it by saying, okay, now we are at the risk of default, and we can force the city. So here's just so that you're not worried. Here's what Harvey was paying. You know, they're paying less than 1% of what they're required. Certainly never more than 30% of what was required. Here's what the city of Chicago is paying. They're close. They're paying 80% of what we're required. You know, they're making substantial payments in the city of Chicago. So we're not Harvey. But it does show that what it shows us is the roadmap if we needed to file suit against the city, how we would do it, and I'm relatively comfortable that we would be extremely successful if we ever had to do it. Now, in Harvey, just what the court did is that it ended up assessing damages against the city for the $15 million that was owed. Our numbers obviously would be astronomical. I mean, what's the unfunded liability, Steve? What's the dollar amount? Like $5 billion. Yeah, so we would get a judgment against the city amount of $5 billion. That'd be kind of fun to collect on, but I'd like to depose the mayor on that one. But basically, what Harvey does is says also, it reaffirmed that the controller intercept is the way to go. So when you need your money, and so that's what the Harvey people did. They went in then and intercepted money, and they were forced to lay off people, but again, it put the burden in the right area. It said, you've got to fund the pensions. City of Harvey, do what you have to do to make it possible. And that may mean layoffs, it may mean changes in how the city does business, but it wasn't on the backs of the pensioners, which is what's important. Okay, the last case that just came down a month or so ago we wanted to tell you about, because it's a little disconcerting, is the city of Cranston in Rhode Island. And that's a case that's different because in that case they did say that the mayor could change the COLAs. So if I were the mayor, I'd be reading this case very, very carefully, because I'd be thinking, how can I use this case to my advantage? But it is a different case. In Rhode Island, it was an ordinance. It wasn't the state in my Bible. And it wasn't a constitutional protection. And also, in that case, it was very clear that Cranston had serious issues that required it to not pay the COLAs. And I just think it's a different situation. But I will say that what happens in this case, and we're going to continue to watch it, is that it's something that you might see down the road from the city. If I were the city, they might try to go back after the COLAs under an analysis like this case, where they say that it really affects the ability of the city to do what it has to do. Now, again, it's a totally different situation. The financial situation of Cranston is not nearly the same as the city of Chicago. So there are these differences. You guys, we're going to have this presentation up on the website at the FABF, and you guys can look at it in more detail to see the differences. Why I'm not really worried about Cranston, but again, your trustees want you to be fully informed. They said to me, tell them every case they could affect it. Okay, so now, to kind of talk about it, this is our funding, and this is the slide, John, I told you I'd come back to. You can see we're in dire straits on funding. But again, not to worry, because they have to pay us. This should be a chart that makes the mayor nervous, and her people nervous, not so much us. And this is the chart that kind of confirms what Danny and Danny was talking about, Danny Fabrizio was talking about the cash flow rate. You can see that for a long time, we were spending about $130 million more than we were taking in. That's pretty bad. But with the advent in 2016, when we got more money from the city, look, our burn rate went from $130 million to $51 million. That's pretty good, right? And now 2017, it got a little higher, but then now in 18, it's low. Again, a little higher, but each year to ultimately the deficit by 2021, when we get ARP funding, hopefully goes down to no more, a plus column of 30 million. So that's a pretty big swing, right? If we get ARP funding. So we are monitoring that. We're making sure that we kind of take care of it. But again, all we're doing in this is showing you that things are beginning to improve from 2015. And again, you guys understand negative cash flow, right? It's just the fact that we're spending out more than we're taking in. Okay, so really, what can you do? What you guys can do, in my opinion, is you got to monitor pending legislation. There's all kinds of legislation popping up all the time. Your trustees at the pension fund are all over it, trust me. But if you guys can weigh in or make sure you read it, understand it, if you have questions, call the pension fund. We're always there, willing to help so that you understand it. But don't ignore it. You know, I think like when the mayor a few years ago took away health care for retirees, I couldn't believe there wasn't more of a stink by retirees. And I think people weren't just paying attention. So I think you need to pay attention to legislation. Start monitoring it. I think that there's going to be, and I don't have any knowledge, Mr. Tubbins would know a hell of a lot more than I would, but I think that there's going to be some, maybe in the veto session, which is at the end of October, and the middle of November, a couple days, they're going to talk about legislation. You guys ought to watch that, keep alert to that, because again, it's one of the tools that's going to put money into your pension fund. You should contact your legislative leaders. One of the things we were asked yesterday, and we're going to do it, because we learned from you guys, we want to learn from you guys, is, hey, tell us who our legislators are. Give us their phone numbers, and we're going to do that. We'll put that on the website of the Fireman's Fund, so you guys can look online and know who you should contact and tell them that you're worried about this stuff. Continue to read the reports we give you on our annual reports, and if you have problems or it makes you concerned, give us a call. We're happy to talk about it. I do think that you're probably going to see a change in the ramp. If I had to guess, I think that the mayor's probably going to want to push that ramp. You should understand that when it happens. You should call your pension fund, ask your trustees. Always they're going to fight that, but they're going to make sure that they explain it to you so you understand the ramifications. Now I will say, and it's always hard for people to understand this, but really your benefits with respect to what's provided by the pension code are not within our lane at the pension fund. The law limits what your pension fund trustees can do. All we can do is administer the fund. We're like, your trustees. We just monitor and administer your fund. The union and the employer really are the ones who are in control and help protect your benefits. And you need to support them in that. You need to make sure that the union knows what you're thinking and how they can help you with that. What we do, the one issue that the pension fund can legally get involved with is funding. Because that's our obligation, is to make sure we pay you your pensions. So whether COLAs or other benefits, that's really something for the union, but you can always let us know, and we'll be happy to direct you to the right people to get your comments from. And also you should know, and we told people this yesterday when they asked, we're happy to work with the union anytime to provide information or be a resource to you or to the union as they navigate these very complicated issues on your behalf. But the pension fund is kind of limited by statute, by the Bible, to just really administering the fund and fighting to protect funding. That's our kind of role. Okay, so I wanted to end with this. Trustee Fortuna and I we went out and actually had a glass of wine after this because it made us so happy that the mayor ended her speech by saying, but as I've made clear many times, pension obligations are a challenge that must be met. Dedicated city workers have fulfilled their careers and they need to retire with the dignity and the certainty pensions afford. Our obligations are not optional, and I will take every action necessary to fulfill the promises we made. So I think that's a pretty good, strong statement from the new mayor. She knows she's got to do this. You're gonna have to be patient as she figures out how to do it. But if you come away with nothing else today, it should be the sense that your benefits are protected. You're going to get your benefit. It may not be the way you like it. They have the money in the bank, but you're going to get your benefits, and they are protected under the current law. So watch what happens if the law changes. I think it would be hard. Anything that would affect your benefits under those cases we talked about would likely not succeed. But you guys have to make sure you stay on top of it. We're there as your advocates. Trust me, 24/7. We're trying to protect your benefits, but we need your help. Okay, any questions? Great. I hope you understood it. Again, if we can do anything, Steve Swanson knows how to get a hold of me. I'm happy to help anytime I can. Thanks.